supposed to do?
I ain't doing nothing to nobody. What I'm supposed to do? I'm trying to take care of my nieces and nephews, running back and forth.
Okay, pause. Before we go further, let's just acknowledge how many times this man asked, "What am I supposed to do?" It's the courtroom equivalent of "It wasn't at me," but with a grocery store subplot. Spoiler alert, the judge isn't here. For grocery runs, he's here for that knife in a bear situation.
To the store and stuff. What I'm supposed to do? What you want me to do?
If you need things, we can...
All I'm doing is the best I can. I'm not doing nothing to nobody. What you want me to do? I didn't have nothing to do with that.
Mr. LeDon, you are on bond for a terroristic threat. You've now picked up a criminal mischief. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 11th, 2025, the officer responded to a physical disturbance at a residence in Harris County, Texas.
Oh wait, hold up. A stuffed animal with a kitchen knife hidden inside. That's not just criminal mischief, that's full-on Build-A-Bear Break-A-Window edition. Who even thinks of this? And now we are entering serious territory. Concealed weapons, broken windows, and a he-said-she-said spiral that's about to get messy.
Dispatch advised that the caller was reporting he had a knife and was going to stab someone because they were bothering him about a broken window. The officer made contact with the defendant and the complainant, and the defendant stated he called the officer. The defendant was found to be in possession of a green stuffed animal which had a fixed blade kitchen knife concealed inside. The defendant stated the complainant came to his house with her roommate, accusing him of breaking a window at her apartment.
Well, hold, you're going really fast.
Yes,
The defendant,
called the officer.
okay,
He said that the complainant had come to his house with her roommate, accusing him of breaking a window at her apartment. The defendant stated he was walking back to his apartment, and that the complainant came out the back.
Great question, Your Honor. That's the million-dollar mystery. Who actually broke the window? Because right now, all we have got is an emotional witness, a suspicious stuffed toy, and a defendant who keeps switching his story like it's a courtroom choose-your-own-adventure.
Door to her apartment, but then he changed his story, saying that she came out the front door to her apartment to confront him. The complainant stated that the defendant stated that the complainant came with a gun, though he did not see the gun. The complainant stated that she was laying in bed, heard a glass window in the back door break, jumped up, ran to the back door, and saw the defendant walking away from the door, holding a green stuffed animal with a knife. Apartment management stated the cost to repair the window was $200.
There's a lot of randomness in it, Judge.
the only thing my concern is who broke the window? Did he break the window?
And Your Honor, so according to the gym, what the complainant says is that she saw him walking away. She heard the broken window, and she came downstairs and saw him walking away. And then that's what we have in the gym. And then I spoke with her yesterday as well, and she repeated the same thing, that he was the only one there when the window was broken. And that's what she said. She saw him outside the window door when it was broken.
He's walking away. He actually calls the police because he's being harassed by this woman because she's saying that he broke a window. And I don't think there's any list of physical evidence like glass on him or anything, or in the whatever stuffed animal.
At what point did the cops come and did they arrest him on the spot? What, do we have any other physical evidence? Do they?
We have the two brothers of complainants said that he was approximately 20 feet away from the back door when she saw him, and that the officer found the window to be shattered. And then the complainant showed the back door to her apartment.
I mean, how do we know he did it?
No one's saying that he did.
I mean, no one saw, you know? It's,
To be honest, just what we have is that the window was broken, and then she saw him outside at the time when she came downstairs to check out. That's what we have.
I get it. I
Yes,
get it.
Judge.
I don't think it's enough. However, the fact is, we're still having issues with the same complaining witness. I now have to take more drastic action to ensure nothing happens in the future.
And here comes the real consequence. No conviction yet, but the judge is not waiting around. Ankle monitor activated. And a 500-foot no-go zone. That's legal code for stay away or go to jail. When physical evidence is murky, judges fall back on preventive control. This is textbook risk mitigation.
So now what I'm going to do is I'm putting an ankle monitor on it and I'm barring him from going within 500 feet of where she lives or where she works.
Yes, Judge. Ankle monitor, just want to make sure it's ELM and not scram.
Correct.
Okay. Ask that fees be waived. Okay. I'll add.
How far do they
Judge-
live from each other, Alex? You know?
Do you think there's any complaints?
It was described as across the street. But when I spoke to the complainant, she said that they do not live across the street, that he was staying at a friend's house, but he told officers that he lives across the street.
So what I'm doing, Mr. Franklin, is I'm going to put a monitor on your ankle, and there is a radius of where you cannot go where this person.
Now, here's where it really escalates. The original bond condition, no weapons, but if this stuffed animal knife counts, that could be a bond violation. And trust me, judges do not take kindly to violations, especially when they involve weapons. Watch closely, this could trigger jail time before trial even starts.
Lives or works. And I mean, we may have issues with bond conditions as it is, because if I ordered him not to have weapons on the terroristic threat, and they show me that, or they prove to me that you have weapons, I'm going to put your butt in jail. So maybe we should have a formal bond hearing to see if, in fact, you can prove that he has a weapon.
Yeah, yes.
So I have some hesitancy about everything, Judge, mostly because my client's orange sheet is quite extensive. So the jail has diagnosed multiple mental illnesses. I'm trying to track down his competency because I was appointed, I think, December. So there's been prior competency motions. I'm trying to get the reports from them, which is difficult because I forget what agency does the mental health evaluations. They're saying that they don't exist. So I'm trying to find his mental health records, Judge. It sounds to me like it's bipolar schizophrenia or schizoaffective. And so I think that my client is likely going to have severe mental health issues, which have been causing issues. And I think that's going to be the heart of all this. And so I'm trying to push for treatment. The case is just brand new is the problem.
You were ordered not to be in possession of any weapons. And they're telling me now that you have a new case and that you have an alleged knife as well. I want to set this for a formal hearing on Monday. And if they show me that you have a weapon in violation of your bond conditions, I'm going to bring it. Do you understand? You are not to be in possession of any weapons whatsoever. Get a hold of your witness.
End. There it is, the legal lifeline. One more week, but make no mistake, this is the court's version of a countdown clock. Defense has 7 days to pull evidence, secure reports, and prep for a bond hearing that could decide this man's freedom, the stakes, knife possession, mental health, and a very watchful judge.
Get a hold of the cop. Let's have a formal hearing on Monday to show me whether he's in possession of a weapon or not.
Yes, Judge.
Yes, Judge.
In the meantime,